Welcome to the Pencil Bob channel. I hope you enjoy my stories.
This situation serves as a stark warning for anyone considering buying a home in a homeowners association, HOA. We are currently facing a lawsuit from our HOA over what we believe are unjust violations. These alleged infractions have led to 3 liens being placed on our property, resulting in thousands of dollars in fees and fines. The financial burden and stress from this experience have been overwhelming. It's crucial for prospective homeowners to understand the risks associated with HOAs, including the potential for aggressive enforcement of rules and the serious consequences that can arise from seemingly minor issues. Our experience underscores the need for caution and thorough research before committing to a home governed by an HOA. We moved into our home in 2020 as first-time homeowners, excited to start this new chapter. After 3 months of living without any issues, we received an email from the HOA inquiring whether the truck parked in front of our house belonged to us. My husband responded affirmatively, assuming the HOA was simply verifying that the vehicle was associated with a resident. However, this seemingly innocuous response led to immediate repercussions. The HOA imposed a fine on us for violating their parking restrictions, which we were unaware of at the time. This incident highlighted the lack of clear communication regarding the HOA's rules and regulations, leaving us feeling blindsided and frustrated by their enforcement practices. It also raised concerns about how quickly the HOA could act on perceived violations without prior warning or an opportunity for clarification. This is a city street that the HOA does not maintain. There are no parking signs. It's a parking strip that runs along the back of other houses, not in front of anyone's driveway. Dozens of other cars are parked there constantly. My husband worked a full-time job out of the home, so the truck moved every day. It is not a commercial vehicle or derelict in any way. We emailed back and forth trying to understand why we were being fined. They just kept coming back to the CCRs that state, no vehicles shall be permitted to be parked on the street within the neighborhood for more than 12 hours within any 48-hour period. We tried to reason with them on the grounds that we have a 1-car driveway for a 3-bedroom house with a 4-person family with 2 working parents that need vehicles to get to our jobs. Their response was along the lines of, our records show you have a garage and a driveway, so you should be fine. Unfortunately, neither of our vehicles fit in our garage. We bought our house as new construction, so only the framing was done. We planned to park my car in the garage and our truck in the driveway. I drive a compact sedan. We had no idea that the builder would put the water heater in the garage with a post that took away multiple feet of space for parking. The floor plan for our home was provided by the sales office, but it did not detail that the water heater would be in the garage. After that, my compact sedan did not fit in the garage. It's now too short for anything but a smart car. From the back wall to garage door is 17 feet 10 inches. From the pole to garage door is 14 feet 10 inches. My car is 15 feet 4 inches. We were sold a home with 2 parking spots, but they created an impossibility for us to utilize one of them. They obviously didn't care and continued to fine us. We requested proof of the violations multiple times, which they are required to provide in regard to the CCRs, but they never did. We continued paying our dues while disputing the fines. Our dues were $60 a month, and the fines were $100 each. At that point, they started applying any payments we made for dues to the fines, even though they were specifically noted as being for dues on each check. Since they were not applying it to our dues, it caused late fines and interest to accrue, which eventually led to them placing a lien on the house. We know we were being targeted because we are in good standing with all of our neighbors, who also park on the street because their garages aren't big enough. None of them were being fined for the same actions, which is one reason we suspect selective enforcement. We then told them that we would not continue paying the $60 a month dues if they were not going to use the money the way the checks were notated. They were misappropriating our funds, and we were not agreeing to pay the fines until they could prove the violations were legitimate. Then they tacked on another lien. Not only did they record a second lien, but they rolled the amount due from the first lien into the second without dropping the first one. According to the county assessor's office, the process should have been to update the first lien as opposed to recording a new one. At this time, the HOA board was being run by the developer of the neighborhood. We could clearly see that our efforts were going nowhere with them, so we waited it out until the actual homeowner board took over. thinking they would be more reasonable. As soon as the takeover happened, we started attending meetings, which were not open to homeowners before the takeover. At one meeting, one of the board members stated that they know our portion of the neighborhood has challenges adhering to the parking restrictions, so they would not be enforcing that rule from then on. We requested a hearing with the board to get back in good standing with our account. Multiple letters were sent in the mail, as well as dozens of emails requesting a hearing. We were denied the meeting over and over, and then they ghosted us for months. During that time they placed a third lien, again in the same fashion as the second, rolling the balance of the second lien into the third without canceling the first two. The meeting was finally granted 14 months after the takeover. At the meeting we explained our situation. We had spoken to other neighbors who were in similar situations, not regarding parking, with egregious fines and liens placed by the developer board. Those neighbors were given the opportunity to present their case almost immediately after the takeover. The board took their complaints and decided to forgive the past fines and move forward. However, we were not offered the same. We were met with hostility and told that if we did not pay our balance in full they would be hiring a lawyer, and that we were free to do the same, but they have a lot more money than we do, and their lawyer would crush ours. Multiple times in writing, we requested access to review any documents or records relating to our property in accordance with Washington state law, which states that access should be permitted as long as requested for a reasonable time within business hours. We were met with denial and an offer to provide copies at a cost. About this time we received a call from our local police. We live in a relatively small town and know most of the officers. They told us that they received an anonymous call claiming that there was an abandoned vehicle in the neighborhood. The police responded and immediately recognized that it was our truck, so they called to confirm, and nothing more happened because it was in fact not abandoned. They told us we could access the call on the Cressa Clark Regional Emergency Services Agency website. We found the call, and it turned out to be one of our board members. They lied to the police, claiming they didn't know who the truck belonged to. Just another example of their continued malicious behavior. After our own calculations, and some best guesses because they had the worst accounting practices ever, we sent a check to cover any past dues that were missing as well as the late fees attached, which we repeatedly offered to do once we were able to meet with the board. We knew we moved into an HOA and had agreed to pay the monthly dues when we bought the house. In no way were we trying to get out of that responsibility. The concern was the debt they were drowning us in because of the unjustified fines. After years of fighting this, we were served with a lawsuit. We have followed the lawsuit procedure, responding to each of their claims. Once we entered the discovery period of the suit, we submitted our discovery request for proof and documentation of the violations, as well as the accounting records for our property to the initial filing attorney. We sent the letter certified with return receipt requested, so we know that request was received on June 17th. In response, we received a notice of withdrawal from their first attorney. The current attorney has still failed to send any documentation beyond a summary of the accounting. We responded to that with a settlement offer to pay the remaining outstanding dues of which we were not previously aware, and the appropriate late fees for each of those payments. Within the last month, one of our neighbors 2 houses down reported to the HOA that a vehicle had been parked on the street in front of his house for over a week. The response from the HOA in an email was, "We can't do anything about it because the car is parked on a city street and the HOA has no jurisdiction over it." We don't see how they can claim to have the authority to bring this lawsuit when, in their own words, they have no authority over the same public city street upon which we park. Our mandatory scheduling hearing was on September 6th. We appeared before the judge in person, and the HOA attorney appeared via Zoom. The first thing the judge pointed out was that the attorney had not submitted the joint status report. The attorney said she did send in a report, but that it wasn't joint, meaning they did not work with us on it like they were supposed to. The attorney then said that this case was just sort of dropped in her lap, and after briefly reading over it, she didn't really understand why this suit was being brought in the first place. She said she received our settlement request and sent it to the HOA, but they have not been responding to her. She said that she wasn't able to update us because she didn't have our contact info, even though my husband's phone number was clearly printed on the top of the letter she was referencing. The judge asked if we were willing to share an email address to communicate as well. We said yes and provided it. The attorney asked that the trial be set for as far out as possible in the hopes that we can reach a settlement and avoid trial altogether. I asked for it to be as soon as possible, because we have been dealing with this for 4 years, and I didn't want them to drag it out even further. The judge took both opinions into account and set the trial for January 13, 2025. My husband then pointed out that we had submitted the discovery request back in June, but we still haven't received anything. The judge asked the attorney why that was, and she said she hasn't seen that document, even though we have a signature proving it was received. The attorney asked that we send it again. We agreed to do so. She said she would email us that day, now that she has our email, and that we could reply to that and include the discovery request. It is now 2 days later, and we still have not seen an email from her. Make sure you're requesting your attorney fees in a countersuit, as well as compensation for the pain and suffering caused by the headaches and stress they have inflicted on you. It's important to document all the challenges you've faced due to their actions, including any emotional distress and financial burdens. Additionally, emphasize that the road in question is maintained by the city, which undermines the HOA's authority to enforce parking restrictions in that area. This point strengthens your position, as it indicates that their enforcement may be overreaching and not legally justified. By clearly outlining these factors in your countersuit, you can build a strong case that holds the HOA accountable for their aggressive tactics and seeks appropriate redress for the difficulties you've endured. Proceeding pro se is just idiotic in these litigious times. In addition, when 2 attorneys are involved, they can't pull the kind of shenanigans regarding delivery of documents and discovery that OP has had to endure. Lastly, an attorney, being a friend of the court, has much more credibility before the court than a pro se litigant does. You should consult an attorney to at least get an idea as to whether this case can get dismissed. Ask an attorney, but it sounds like the HOA may not have a case. If it's something that could be dismissed, you can countersue for damages, or you could end up spending less on an addy than you would if you settled on your own. Hell, an attorney can advise as to whether it's even worth trying to settle or whether settling is a tactic on the HOA's part to get paid off of a bad case.
I would like to thank you for watching the video to the end. To encourage us to make more videos, please like, subscribe, comment, as well as share. Check out this other video if you haven't already.